application and appeal in the matter of Gill and Lees News Limited.
Yes, Mr. Grundy.
My lord, before I get to the application, you should find each of you in front of you an A3 sheet of paper.
Yeah.
That is the document that appears in the bundle, the supplemental bundle, as an A4 document,
Yes.
and is illegible. The whole of the schedule, it's Mr. Hirrell's schedule that he produced after the disclosure in July 2021, but I wanted just to take you to some words in it, and in order to do that, I've produced an A3 copy so that it's legible. I've put my copy in the supplemental bundle at the appropriate page. It is paginated if you wish to do that. My lords, I represent the appellant in this matter, Harmohinder Singh Gill, as trustee of the Gillcrest UK Pension Scheme. My very learned friend, Miss Wicks, leading Mr. Ben Nolan-Smith. Walker Nolan, I apologise. Leading Mr. Walker Nolan, represent the respondent defendants. The first matter in front of you, my lords, is an application by the appellant to rely on a supplemental skeleton argument.
Yes, now we've read that, and we all have some sympathy with Miss Wicks's confusion about what exactly you are, which parts of the original skeleton you are abandoning, which parts you are pursuing. My lord, yes. And what your attitude is, or your submission is rather, towards the decision of this court in Usafi.
My lord, yes. So perhaps I just want to make a cheap point before I do. At the end of Miss Wicks and Mr. Walker Nolan's skeleton argument, there's a line that says A has in fact proceeded, treats litigation as a game in which, I think they mean the way in which A has in fact proceeded, treats litigation as a game which R has to pay its legal team large sums to guess what might be coming its way from time to time. In my submission, there's clearly nobody on that side of the courtroom who has any sense of irony, or they have a Johnsonian attitude towards shame, not Dr. Johnson, but Boris Johnson. Their clients misled the landlord and the tenant and the court for a period of over 3 years. So I don't think it behoves them really to say this doesn't comply with the rules at this point. Dealing with your questions, my lord. Insofar as it is, I recognise that in the supplemental skeleton argument it refers to the disrepair ground section 31A, and that the original skeleton argument deals with the litigation conduct under ground 31C. In my submission, in fact, both of those apply.
To ground A?
No, both to the litigation conduct.
Yes.
Both ground 31C and 31A apply.
Right.
And I apologise in the supplementary skeleton argument for referring only to 31A.
So, are you saying the litigation conduct is to be taken into account under C or A or both?
It could be taken if it's in relation to the performance of the repairing obligation, which it was in this case. It could be taken into account under 31A or under 31C or both.
Right.
Insofar as Usafi and Musselwhite is concerned, insofar as that has been construed as saying the discretion is a discretion like the Rent Act discretion when a case for possession is established, or the discretion under the Housing Act 1985 or 1988 when a reasonableness ground for possession is established. My submission is that Usafi and Musselwhite is wrongly decided.
Don't think anybody suggested that.
No, I don't think they have either. But that is what is raised in Hill and Redmond. So if I could take you to the authorities bundle, my lords.
Yes.
And it's page 280. It's behind tab 20.
280.
280. That's on the pagination. It might be page 2. It will be page 281 if you're electronic.
I've got a page that starts, however, Ormerod.
Yes, that's right. If you go down just over a third of the way down the page to where just below the hole punching is
the nature of the court's discretion.
My lord, yes. If you read that paragraph and then the two subsequent paragraphs to yourselves, rather than me reading them out,
yes,
you'll see that the authors of Hill and Redmond identify a proposition that Lady Justice Gloucester in Yousefi and Musselwhite was suggesting that there is a different discretion under ground A as opposed to grounds B and C.
Yes.
But my submission is that in either case, however one reads her judgment in Yousefi and Musselwhite, she isn't saying that you can have a general regard to all things that are relevant in the exercise of the value judgment under one of the fault grounds.
I am not sure I quite understand that. Question may be what is relevant, but you surely must be able to have regard to all factors which are relevant.
Yes, that, my lord, that is the right way of putting it.
So
what is relevant?
What is irrelevant?
What is irrelevant might be, for example, the fact that the tenant bought the premises in a poor, or took over the lease in a poor state of repair.
Right.
Or that the landlord is a hands-off landlord.
Right.
And those would be irrelevant whether it was under ground 31A, the disrepair ground, or under 31C, the breach of other conditions and other conduct.
Yeah. All right.
Well, was the purpose of the...
So you're not saying Yousefi was wrong, you're saying it has perhaps been misinterpreted?
My lord, yes. And certainly it seems to me that that is how, or that the passage in Hill and Redmond appears to indicate that that might be how it is being construed.
Right. Now, I think that is a contrary position to the original skeleton, which did seem to suggest that Yousefi was wrong. Is that right?
Well, I think the original skeleton argument says that under Yousefi and Musselwhite, sorry, I apologise, my lord. My position is that I'm effectively consistent with the original skeleton argument, which is saying that there is, not that Yousefi and Musselwhite is wrong, but that there is an interpretation of Yousefi and Musselwhite that's allowing a wider look, a more, a less constrained look at all of the relevant factors.
No,
So,
I think it was a common ground, wasn't it, before Mr. Justice Richards, that Yousefi was wrong. And that
well, that interpretation,
and the court should not take a compartmentalised approach.
my lord, yes, that approach to Yousefi and Musselwhite is wrong, my lord, yes.
Sorry, what approach?
That the court should, that under ground 31A, the court is not constrained merely, and under ground 31C, the court is not constrained merely to look at the breaches that have happened and the conduct, but can look wider.
It can look wider.
But within the constraints of within the constraints of each of the grounds. So you can't have a general overview of whether or not it's fair or not in all the circumstances to make a possession order or to refuse to grant a new tenancy agreement.
So that then means that under the second half of C, anything which is connected with the tenant's use or management of the holding would be relevant, doesn't it?
Yes. And you might take the view that that's really quite a wide purview.
Yes.
My lord, the supplemental skeleton argument arose in part out of having read the basis upon which your colleague Lord Justice Newey, your fellow Lord Justice Newey, granted permission to appeal, and looking at what he said about what he had identified in the grounds of appeal as the basis upon which he was granting permission, being whether deciding when a tenant ought to be granted a new tenancy in view of breaches specified in section 30, the judge may have regard to matters unconnected with the breaches or must rather focus on fairness to the landlord. In my submission, the or in there is rather redundant because they may not necessarily be inconsistent or they're not mutually exclusive. You could focus on fairness to the landlord and only have regard to matters connected with the breaches, or you could have focus on fairness to the landlord and have regard to matters unconnected with the breaches. So the three questions that I've posed in the supplemental skeleton argument, my lord, arise out of the respondent's notice and out of the grant of permission to appeal.
I see.
So I don't abandon Mr. Lane's skeleton argument, and in my submission, the grant of permission was clear about the basis upon which Lord Justice Newey considered that those grounds raised an arguable case.
Yeah, all right.
My learned friends complain about Mr. Lane's skeleton argument not being very clear, and I had hoped to provide them with some clarity. I was aware of the haggling going on in the background about their concerns about not understanding how this was going to be argued. And the purpose of the supplemental skeleton argument wasn't to resolve from any of the grounds. It was rather than providing a stream of consciousness, it was to provide a focused approach to what I regard to be the three questions. Dealing finally with them with time and exceptionality, I think the parties have been aware for some time that this hearing was going to be today and not on the 4th of October. And I certainly emailed the skeleton argument, and I understand that those instructing me emailed the skeleton argument to those instructing my own friends, but I emailed it to my own friends on the 26th of September. So if and insofar as the 7-day time limit makes any difference at all, they had it 8 days in advance of the hearing. My lord, I will make my submissions as I make them on the basis of Mr. Lane's skeleton argument and the grounds. The purpose of that supplemental skeleton argument was to provide focus. If you refuse it to go in, so be it.
Ms. Wicks, they're not exactly difficult points which need lots of research, are they?
Sorry, which points?
The points being taken in the supplementary skeleton.
The points being taken in the supplemental skeleton, absolutely not. I'm not suggesting that this is an issue that we can't address at the time available. The difficulty with it is, as we submitted in our skeleton argument, the inconsistencies, so that the supplemental skeleton is neither one thing nor another. It's not really supplemental to the existing skeleton argument because it doesn't take those arguments further or fill gaps or add authorities, but it's not a wholesale replacement either. So we are left in a position where it is really quite difficult for us to know exactly what the arguments are that we're going to have to address. And in circumstances where the rules say a supplemental skeleton argument should only be put in where strictly necessary, it didn't seem to us that that...
Well, I mean, we are minded to let Mr. Grundy make his submissions, and if you are embarrassed, then we'll deal with that as and when.
Thank you, my lord.
Yes, Mr. Grundy.
My lord, thank you. Unusually, the way in which I'm going to approach this is to take you through the documents that give rise to the timeline by which this case came to trial before his Honour Judge Monty, and then I'll return to the law. Will largely be in the supplemental bundle, but there will be some documents that appear in the core bundle. So the first document is at page B118. When I use the prefix B, I'm referring to the supplemental bundle, documents in the small bundle word, prefix A. So B118.
Yeah, Mac Roofing.
Mac Roofing, what I ask you to look at there is the date, 22nd of September 2017. And the fact that it's an invoice for work carried out, so the work has been done.
Yeah.
My lords, on the 31st of August 2018, so just under a year later, the Section 26 notices were served by the tenant in this case. On the 26th of August 2018, the schedule of delapse was produced, a schedule of dilapidations, and that ends up as part of the February report of, the report of Mr. I apologise. It ends up as the part of the December report of Mr. Colborne, but the schedule of dilapidations from October 2018 starts at page B187. Clearly, given that the inspection for this took place in October 2018, it postdates the Mac Building invoice and the works done by Mac Building. If I could just ask you to turn to page B196, my lord. And in the same way that His Honour Judge Monty did, we'll use the roof as the kaleidoscope through which to look at everything else. So A1 is the roof. And you'll see there, poor repairs to flat roofs, existing deteriorated roof covering overlaid with single layer of mineral felt, including parapets to party walls, section of flat roof decked inadequately supported, timbers rotten due to historic water ingress, and then some works are set out.
Yeah.
That's required.
The costs are estimated costs, are they?
Yeah.
Yeah.
On the 19th of or 20th of November 2018, Clerk Wilmot, who was then instructed by the tenants, wrote to Mr. Gill's then solicitors, and that letter is at page B114. And I say this is the point at which Mr. and Mrs. Nathan start to mislead the landlord. So you'll see they refer to the grounds 1A. They've had the counter notice indicating opposition, and they've also had a copy of the schedule of delapse.
Yes.
I'd refer you to the paragraph starting at the bottom of page 114. Further, we are instructed that should the leases be renewed, the Post Office intends to carry out refurbishment works at the premises as part of its transformation project, which would involve extensive works inside the premises from floor to ceiling and works at the fascia of the premises. Again, should that happen, any repairs that our client might carry out now would be superseded by such refurbishment works. Nonetheless, should your client persist with this ground, then it is our client's intention to carry out such repairs as are required to comply with the terms of the leases well before this matter goes to trial. Our client is also willing for new leases to be granted on terms that our client undertakes to carry out such works as may be required to comply with the terms of the leases if required. Consequently, your client is likely to lose on this ground. If I take you back to the top paragraph under ground 1A, you'll see they say, we note that your client is seeking to allege that there are substantial breaches of the covenants in the leases relating to repair and maintenance. Our client denies this. We are instructed there may be some minor breaches of the repairing covenants in the leases, as would be common for a property of this sort. So notwithstanding they've received a schedule of dilapidations produced by a member of the Royal Institute of Chartered Surveyors, they say those don't amount. Okay, that's what they say. There we are. On the 15th of August 2019, the particulars of claim were drafted, and they are in the core bundle right at the back, my lords. It's tab 15, my lords. Claim form is at A236 and A237. The particulars of claim refer to the grounds of opposition, but make no reference in my submission to or the fact that the premises are currently in disrepair. We don't accept any substantial disrepair or say we will, before this case gets to trial, remedy what disrepair there is. The defence, my lord, is also in bundle A, that's behind tab 14. Paragraphs 12 and 13, which are at A230 and A231 to 232. The particulars of ground A are set out. And then at paragraph 14, the schedule of dilapidations is referred to. So there's going to be no doubt that what the landlord's position is. For some reason, this case took almost a year to get to a CMC, but the order is under Judge Monty, dated the 2nd of October 2020. Is at page, back in the supplemental bundle, B5 to B8, and it sets out a timetable.
B5, you say?
B5, my lord, yes.
Do you mean A5?
No, it's in the supplemental bundle, my lord.
Tab B?
No, not, sorry, there isn't a tab B, I apologise. It's at page 5 in the page 5 in the
Oh, I
supplemental
see.
bundle. I apologise.
Yeah.
Sorry, they have just been numbered to distinguish them from the
Yeah.
core bundle as B numbers.
Right.
So if you you'll see that part 18 requests are dealt with in paragraphs 6 and 7, disclosure paragraph 8, witness statements 9 and 10, and expert evidence of paragraph 11.
Yes.
So there was the timetable. Next in the chronology, we get the entry on the 6th of October into the construction contract. And that, my lords, is at page 248, B248.
Yes.
And that's dated the 6th of October 2020. It's made between Let's Construction and Mr. Nathan.
Yes.
And it says that the works that are going to be carried out are set out in Schedule 1. We turn to page Schedule 1, which is C264. You can see there the description of works as detailed on the schedule of dilapidations produced by Daniels Harrison Chartered Surveyors Limited. So presumably that's the October 2018 schedule of dilaps.
Yeah.
The agreed price was £30,000. If we turn back, my lords, to page 248, you'll see there that it says on paragraph, under the heading, the parties agree as follows. The services will commence in April, May 2021. So notwithstanding that this was executed in October 2020, the services are going to start in April or May 2021. The next thing in the chronology is on the 10th of November, so 5 weeks or so after this contract has been entered into, the tenants produced Part 18 replies, and there it be 105 to 113. So the question number 1, my lords, is on page 106 over the page. With reference to the items identified in Part 1 of the 2018 schedule and using the same references as contained in the 2018 schedule, please identify which items as at the 18th of October 2018 the second party accepts were in breach of the tenant covenants in the lease, question mark. A1 roof, please see attached copy of the work carried out by Mac Builders. So 6 weeks ago, 5 weeks ago, they've entered into a contract to do all of the works in the schedule that's elapsed, and they're relying on the Mac Builder invoice.
Yeah.
Turn back a page, my lords, to page 105. You'll see there's a preamble to the response. These answers are given on the basis that the questions are legitimate and proper under a Part 18 request of which we are not convinced. We found the layout of the questions extremely confusing. I apologise, that seems to be a difficulty of documents we produce on this side, for the other side. 3, in relation to all matters which the defendant has asked the questions whether there are any breaches of covenants in the lease relating to repair and maintenance, the answer is no. There may be some very minor breaches of the repairing covenants which show up in the answers, but there are no substantial breaches. Number 4, finally, we remind you of the Clark Wilmot letter of the 19th of November 2018, which is enclosed herewith, the contents of which the claimant entirely relies upon. If there are any works needed, we're going to carry them out long before trial.
Yeah, and anyway, you want to redevelop, so what's the point?
Yeah. We then come to the tenant's disclosure. That's at B20. That's on the 19th of November 2020, and that's at B28 and 29. There was some dispute about whether or not it was properly supplied, but I'm very happy to rely on the earliest one because that's closest to the date on which the contract with Let's Construction was entered into.
Sorry, B28.
B28, my lord, yes.
Yes.
So you'll see there, that's the tenant's disclosure. So a contract has been entered into now 8 weeks before this disclosure and is not disclosed.
Right, so number 3, they disclose the MAC work.
Yep. The next thing that the defendants do is on the 50th.
Just to help me about this, I mean, we've seen what the judge found.
My lord, yes.
Don't think there's any appeal against his findings of fact.
No.
What difference would it have made if the tenant had disclosed the Let's Construction contract?
So if as I'm going to submit, the position is that the way in which the perspective or the approach that the court must take is whether or not it is fair to the landlord to order him effectively to grant the tenant a new tenancy. the honesty of the tenant, the openness and the frankness of the tenant saying, I accept that there is disrepair, I'm going to repair it, absolutely impinges upon whether or not it is fair to order the landlord to grant the tenants a new tenancy.
Wait a minute. Are you alleging that the conduct of the litigation was dishonest?
I'm not alleging that it was dishonest.
What was your reference to honesty about then?
What I will say, the tenants were misled the court and misled the landlord.
But not deliberately. Sorry, I don't understand what your shrug is. Not deliberately, because that would be dishonest, and there is no finding of dishonesty.
So I don't, in my submission, if the tenant has behaved in this, even if not deliberate, the tenant has behaved in a way which misleads the court and misleads the landlord, that will have an impact upon the relationship of landlord and tenant and the trust that the landlord can feel in relation to the tenant's performance of their continuing obligations.
That I understand, but there's quite a qualitative difference, isn't there, between deliberately misleading and inadvertently misleading.
Well, my lord, in my submission, insofar as the relationship of landlord and tenant is concerned, no. Because if your tenant inadvertently misleads you over a long period of time, at some point your ability, and in particular where they have obligations because the court requires them to approach the litigation in an open way, and they don't, at some point you're entitled to say, I don't want these people as a tenant for another term.
So if the tenant had disclosed the let's construction contract, the tenant says in response to your counter notice, all right, well, look, we've had some work carried out by MAC.
Yep.
Your surveyor doesn't think they're good enough. We will instruct another contractor, and here we are. This is let's construction. They're going to do the work.
My lord, yes.
That would be the end of ground A, would it? You'd be perfectly happy to have Lees News as a tenant. Is that where you're getting to?
My lord, it is. We will come to the way in which the disclosure of the let's construction contract emerged, which also, in my submission, damages the relationship of landlord and tenant. So it isn't just about if it had been disclosed, but when we deal with the paradigm tenant who's described in Betty's Cafe as somebody who's entitled to a new tenancy agreement, you'll see what they say. What the paradigm tenant says is, yes, there are some breaches. There's a reason for those breaches. There was bad labour supply, or materials were unavailable. I will do everything I can to put them into repair. And then gets on with it, and by the date of trial has got them into repair. What we see here is a tenant who doesn't behave in that way.
Well, he did, he just didn't tell you about it.
Well, it's not just that he didn't not tell you about it, it's that he, having had a number of opportunities to tell you about it, and should have done in the course of what the proceedings required, and the way in which we conduct litigation with regard to the overriding objective is that we are open and we try and limit the matters that are in dispute and come to court to argue about what is substantively in dispute, as opposed to...
Right, well, can we just take this in stages? You say there is disrepair.
Yes.
I'm going to oppose the granting of tenancy on that. And the tenant says, well, yes, there is some disrepair, but it's minor. Now, we can have an argument then about whether the disrepair is major or minor, but they are accepting there is some disrepair. They're not saying MAC has solved all the problems.
My lord, yes.
So then they engage Let's
My lord, yes.
to address the schedule of dilapidations, and Let's does that. They don't tell you about it, but the work is done. And You say they weren't denying that they were doing this work, were they? Or were they? They just didn't tell you about it.
My lord, they didn't tell you about it in circumstances in which the rules of court
Yeah, they should have told. They should have told you about it, and they didn't. Now, is that misleading?
Well, I think if
They
you have an
didn't
obligation,
disclose something which perhaps they should have done.
I think if you have an obligation of disclosure to disclose relevant documents and you don't, in my submission, that is misleading.
Was it at this stage contemplated on their part that Mr. Colborne would be coming back to inspect again?
I have no idea what they were contemplating.
Well,
There was sorry.
We'd had a report from Mr. Colborne.
No, sorry, the earlier report was from another surveyor, but from the same firm, but yes, you're
I'm so
absolutely
sorry.
right.
My mistake.
No.
Someone from
The directions certainly envisaged the preparation of expert evidence,
Yes.
and the communication from those instructing me was that there would be the landlord would be relying on expert evidence.
Yes, which presumably would involve later inspections.
Absolutely.
So that if Let's Construction were carrying out the work, that wasn't something that was going to remain hidden. It would be apparent when there was subsequent inspection by the expert.
On the 2nd of July, when the expert went, he certainly talked to builders from, and we'll come to that in due course, he talked to builders who were instructed by Let's Construction at a time at which the tenants were seeking to rely on Mr. Hirrell to say no work's required.
Yes. So there wasn't really an attempt to deceive as to whether any works were going on. It was patient.
I think that would be that's a very generous, because you are come and inspect and we didn't. So the works were meant to start in April or May and finish in July. So they were meant to be carried out over quite a short period of time. That's under the contract. There's no certainty that the expert is going to inspect during that period.
No, take the roof, for example. Perhaps I'm doing it slow. Take the roof. We've had the report. You've shown us the deficiencies that were found in the schedule of dilapidations. It's going to be apparent on a re-inspection as to whether that work has or hasn't been done, isn't it?
Absolutely. Agreed. You may think that makes it even more inexplicable why the approach that was taken was taken. You might think that even more damages the relationship. Why be misleading in circumstances where your misleading approach is going to be found out?
Well, the courts very often have people who are not competent before them, which is why the relationships sometimes break down. But the judge is probably the best person to make the assessment of whether it's deliberate misleading, just incompetence, and whether it's fair to, as you using your words, foist these tenants on them. Or is that wrong?
Well, I don't think those are three alternatives. I accept that the first two are alternatives, whether they're deliberately misleading or just incompetent. If they are just incompetent, that may arrive at a point at which it isn't fair to foist these tenants on the landlord.
Yeah.
If they are not competent to perform their obligations under the lease, then that would...
Well, that's a different question, if they're competent to perform their obligation under the lease and whether they tell the landlord about it. Your complaint is they didn't tell Mr. Gill what was going on.
But part of the relationship of landlord and tenant is, so the tenant has a period of time in this building, and the landlord owns it. They both have an interest in it being maintained, so there has to be the relationship of trust that a landlord and tenant have in that relationship. If they're doing works without telling the landlord, not just not telling the landlord, but telling the landlord something else, that this doesn't need any works, then in my submission that's bound to disrupt the confidence.
Is that what Mr. Gill said in his evidence? He said, I'm completely broken, this relationship is completely broken down?
We'll can we come to what the judge finds in relation
to any evidence? Did Mr. Gill say to the judge, this relationship has completely broken down, I cannot trust these people anymore?
In my submission, Mr. Gill's witness statement apologise.
It's a simple question, Mr. Grundy.
Yeah.
Did he say that?
The judge doesn't repeat that Mr. Gill said that.
Doesn't repeat?
The judge doesn't repeat in his judgment that that is what Mr. Gill said.
No. Does
That
he
was
say
the submission
does he
of-
say it in his witness statement?
His witness statement was produced in January 2015, 2021, in accordance with the directions, before he knew that the works were being carried out.
And he didn't apply to put in a supplemental saying, well, I've now discovered that
No.
behind my back the tenants have carried out all this work which they didn't tell me about. I can't trust them anymore.
No.
So there was no evidence that the relationship had broken down.
Well, there was oral evidence.
There was oral evidence, was there?
What the judge says about Mr. Gill is that he was a hands-off landlord who wanted the performance of the obligations.
Yes. He didn't find, I don't think, that Mr. Gill had said this relationship was completely
He
broken.
didn't find that, no.
And you're not suggesting that Mr. Gill did say that?
I'm not suggesting that. No. My lord, the next event in the chronology is Mr. and Mrs. Nathan's witness statements, and they're dated the 15th of January. Mrs. Nathan's witness statement is at B 83 to 84.
Yes.
So
She agrees with her husband.
She says, but she goes further than that. She says he does, notwithstanding that he's made the substantive witness statement in English, without the usual translator's statement of truth in circumstances where that has been the case. She says her husband doesn't speak English.
Yes.
But that wasn't the judge's finding.
The judge found that he did speak English,
Exactly.
but she said he didn't.
Yes. What's your point?
So another misleading statement by the tenants, completely unnecessarily. Mr. Nathan's statement complains about the extent to which Mr. Gill communicates with him. He's been attempting to sell the lease, but at paragraph 22 he deals with the allegations of disrepair. So starting at B88, my lord. Paragraph 22. As I have previously outlined, I'm happy to fix all areas that require cosmetic changes. I have listed the works below for ease of reference together with invoices. So he's referring to these as cosmetic. 23. Any external structural building works will have to be repaired by the landlord. So his position in his witness statement is that he doesn't have any structural repairing obligations. No reference to the contract of the 6th of October 2020. Paragraph 24, I have arranged for an expert surveyor to examine the building both internally and externally to provide his expertise on changes required. This will be completed on the 15th of January 2020. Presumably he meant 15th of January 2021 because that's the date of his witness statement, not 15th of January 2020. No expert surveying evidence was ever served by the defendants, by the claimants, by the tenants.
Yeah.
So on the 9th of February, Mr. Colborne inspected
Sorry, which of February?
9th of February
21.
2021. His 2020 his February 2021 report appears as Appendix D to his December 2021 report, and starts at page B137.
Yeah.
So if you turn on, we'll deal with the roof again, starting at page B140. It is claimed by the over the page at B141, second paragraph, start of the first paragraph that starts substantively on that page. It is claimed by the claimant that repair work was carried out by Mac Roofing, set out in their receipt dated the 22nd of September 2017. The evidence in October 2018 of water ingress and timber decay postdates the alleged repair work by Mac Roofing. And at my inspection, a plasterboard finish has been applied to the underside of the joists. Going down the page, the 2 paragraphs below, he says that the failure of the roof is a breach of the tenant's covenants of clause 28A and 28B.
Yeah.
The clauses in the lease, my lords, are at tab 13 in the core bundle. It's tab 13, my lords. And the repairing covenants in the first of the leases are at page A206.
A208, I think.
A208, sorry, I apologize.
Yes.
The principal repairing covenant is an obligation to keep in repair at all times.
Yes.
We'll come back to that in relation to the argument in the respondent's notice. And then 28B, if at any time during the term, whether by reason of age or state of dilapidation or any requirement of any competent authority or otherwise become necessary for the purpose of putting or keeping any building or structure from time to time comprising the demised premises or any part thereof in a first class condition and state of repair to rebuild such building or structure or any part thereof, then the tenants shall at their own cost with all practical speed and under the direction and to the reasonable satisfaction of the landlord surveyors and in accordance with plans and specifications to be previously approved by them in writing carry out such rebuilding. So Mr. Colborne's position is that the work that are required to the roof engage clause 28B.
Now, how is that open to you on this appeal? Mr. Justice Richards refused permission to argue this point. He applied Singh and Das, and at paragraph 55 of his judgment, he said this is a new point, wasn't taken below, I'm not going to allow you to raise it. So how has it formed part of this appeal?
My lord,
Not suggested in the grounds of appeal
No.
or the scope
Well,
of argument that the
it's
judge
very-
misapplied those principles.
no. My lord, certainly the grounds upon which Lord Justice New is allowed appeal to this court refer to,
They do, but that doesn't prevent Miss Wicks from objecting.
my lords, no. My lord, in my submission, it's a matter of, it's clear from His Honour Judge Monty's judgment that he does not refer to clause 28B, and that notwithstanding that there was surveying evidence, the only surveying evidence before him was that there were breaches of clause 28B, he doesn't make any finding that there's been a breach of that clause.
Was he asked to?
My lord, yes, he was, and that's in the in the skeleton argument produced by Mr. Lane for trial.
But if you weren't allowed to argue the point on the first appeal, why should you be allowed to argue it on the second if there's no complaint about the way in which the intermediate appellate court exercised its power to permit new points to be taken?
Yeah. I ought to hear that.
Right, next point.
Going down that page, at page 141, Mr.
Page which, 141?
141, B141.
We're back in the supplementary.
Yes.
Yeah. Yes.
Mr. Colborne, this is his first inspection. The quality of work provided by match roofing is not acceptable. There are several examples of improperly formed drips to the roof edge of the gutters, the lower upper section of the flat roof, and evidence that the top cap sheet has been nailed or screwed to the fascia to hold the edge or retain the edge in place. So he describes in my submission the state of disrepair of the roof. If you turn on to page B155, he suggests some further investigation. As a matter of urgency.
Sorry, where are we? B, is that starting paragraph 5.9?
It does, but B 6.1 suggested further
Point
investigation.
1. Oh, yes. Yeah.
They related to a certain extent to electrical matter, so you'll see he refers to the ongoing danger of death. And then over the page at B156, having reviewed the written statements, so that's what he has at that time. He has the tenant statements, which are saying there is no disrepair or anything is only minor. Together with supporting information from my inspection, I have concluded that the claimant is in substantial breach of repairing covenants as set out above. I recommend further investigation and immediately corrective action in respect of the electrical items.
Yes.
And then his schedule is at page B158. And you'll see A1, the roof. He says there's been no change since the preparation of the schedule of dilapidations in October 2018.
Yes.
On the 30th of April, because the tenant's evidence and expert report didn't comply with the requirements, there was an application made to strike out the claim. And that, my lords, is at B10. Sorry, it starts at B9, I apologise. We don't need to go through that, but there's a witness statement of Sean Meredith in support of that application at B11. On the 6th of July, 2021, sorry, I apologise, on the 2nd of July 2021, Mr. Colborne carried out a further inspection. And if you turn to page B174, my lord. That's his letter dated the 8th of July to,
Sorry, just a minute.
apologise, B174.
B174. Yes.
That's his letter dated the 8th of July to Lawcom solicitors, so those instructing me, those instructed by Mr. Gill. You'll see there, he says, I met Mr. Nathan and Peter from Let's Construction, three other contractors were on site. Although some work had been completed, the majority had not. Jason Hirrell, Let's Construction, had not briefed out to Peter all of the work on the schedule needed attention, as I understand it. So, my lord, to respond to the point made by my lord that if they were doing the work that was bound to be discovered at some point in any event, yes, it was discovered. It was discovered on the 2nd of July 2021.
Yeah.
When Mr. Colborne inspected. On the 6th of July, Lees News Limited made an application for relief from sanction, and that starts, the covering letter, my lord, is at page B63. And the application notice, the first page of it is at B64. You'll see there in box 3 on page 64, my lords, that the relief that was sought, or the order that was sought, was relief from sanction in relation to the claimant's witness evidence served on the 15th of January 2021, and for permission to rely on the evidence of Mr. Jason Hirrell. On the 6th of July, in support of that application, Mr. Nathan made a second witness statement. And that starts, my lords, at page B66. On page B66, he deals with the correct position in relation to his English. At page B67, he deals with the service of his first witness statement. At B67, he says, I understand the defendant's taken issue with the fact that I did not attach some of the documents I exhibit to my witness statement to my disclosure list. So he has another go at disclosure, and that's at B70 to 75. If you turn to B73, which is the list, the documents that are added are on page B74, documents 9 to 20. And they do not include the Let's construction contract.
What were the date of the photographs, which was the amended item 9?
Those will be stated in his witness statement, my lord, in his first witness statement. I apologise, I don't know. Let me have a look.
Thank you.
B83 to 84, 85, 20. So if you look at paragraph 22 and Mr. Nathan's first witness statement on page B88, my lord.
Yeah.
You'll see that item number 6, I have already installed brand new toilet, photograph attached.
Yeah.
So you'll recall that the complaint was he hadn't included in his disclosure all of the documents that he referred to in his witness statement.
Sorry, I haven't understood that.
So,
He says on page B88,
yes,
I've already installed brand new toilet, photograph attached.
yes,
And item 9 on the disclosure list is photograph of the shop front.
yes. Sorry, I
Can't be the same
apologise.
photograph, can it?
No, it can't be. I apologise. Can I just take some instructions? I'll find out. My lord, I can't help with your question as to what the dates of the photographs are.
Right.
I can't find any other reference to photographs in the witness statement, and the complaint was that you haven't included in your disclosure all of the documents in your.
Yeah, anyway, your point is that Let's Construction contract was still not disclosed, even though Mr. Nathan made an updated disclosure list.
And said that this is my full and final disclosure list. So presumably he was reminded as to what the obligation in relation to disclosure was.
Well, he does say in his statement, doesn't he, paragraphs 12 and 13, that after the directions hearing, which I think was the 2nd of October,
That's right.
Let's Construction were engaged to do work.
He does.
So your point is he doesn't reveal there that the work that they've been engaged to do was in fact the totality
of the schedule of dilapidations. In fact, you might say that what his next sentence is misleading, whether deliberately or inadvertently.
Well, it's slightly ambiguous.
Mr. Hirrell.
Given that we were being
That's
advised,
very generous.
well, given that we were being advised that the work needed to be done, we reasoned that it made sense to get on with it.
Well, Mr. Hirrell advised that he did not think that the work being required was extensive or that it would be as expensive as had been suggested. But Mr. Hirrell was carrying out all of the works on the schedule of dilapidations.
Well, that's not in fact right. What Mr. Hirrell had told the contractors that they didn't need to do everything. Your inspector went round and said, yes, you do. And if you look at the original contract, which wasn't disclosed, about which you make complaint, it was for a lot less than the expert had originally costed it for. But it perhaps shouldn't have been, but there we are.
Well, it was for the works in the schedule of dilapidations.
Yeah.
They didn't know what Mr. Colborne's position was at that point. So, with respect, my lord,
in what respect? They knew what the estimated costs were in the
they
original
knew what the
schedule.
estimated costs were. They had the original schedule of dilapidations. They entered into the contract for that work. He is here referring to Mr. Hirrell having spoken to him, presumably in or around October, and him saying, Mr. Hirrell told us that it was less than required.
Yeah.
Well, it wasn't. You've just entered into a contract with Mr. Hirrell to do everything that was then required. It may be it subsequently transpired that more was required as a result of the further inspection of Mr. Colborne, but this is a reference to what was happening in October 2020, my lord.
Paragraphs 12 and 13 are referring to the work that was said to be required in the schedule of dilapidations.
Yes, my lord.
And Mr. Hirrell advised us that he didn't think that the work being required was extensive, i.e.
Not
that which was in the schedule of dilapidations, if all done, he didn't regard it as extensive. He didn't think it would be as expensive as was being suggested in the initial report. But given that we're being advised that the work needed to be done, we got on with it. The work that's being talked about in those paragraphs is the work that was set out in the schedule of dilapidations,
Absolutely.
isn't it?
it is.
And he's revealing there that he's asked Jason Hirrell of Let's Construction Limited sometime shortly after the directions hearing, which was early October, to get on and do it.
It may be that when we look at Mr. Hirrell's report, that this was the application that Mr. Nathan's witness statement was seeking to get adduced. You will see that the position as represented by Mr. Hirrell, who was being put forward as the tenant's expert, is different. So Mr. Hirrell is at page 76 to 78.
Just clarify, if you would, Mr. Grundy, where is all this going? You're not arguing the case at first instance. This
No.
is a second appeal.
My lord,
The
yes.
trial judge reached what I would call a value judgment on whether, in view of the state and condition of the premises, the tenant ought not to be granted new tenancy, and he went
Oh,
through
yes.
all three grounds. You have to show that that value judgment was outside the permissible range for one reason or another.
My lord, yes.
You can't simply say to us, well, you should take a different view.
Well,
That's
no.
not proper ground of appeal. So where are we going with this
So, my lord,
detailed
where we're going,
reconstruction of the
Yes,
of the
right.
chronology?
my lord, yes. Where we're going with this is that when this chronology is, when we go through the conduct of the tenants in relation to the performance of their repairing obligations, or whether it's under ground 31C, we come to the position that if the proper approach, i.e. would it be fair to the landlord to foist this tenant on the landlord for another term, was applied, then that proper approach would require that this tenant should not be foisted on this landlord again.
You're not, are you saying that the trial judge underestimated the severity of the tenant's misconduct?
I'm saying that he approached the matter from the fairness to both sides, as he says in paragraph 81, I think it is, rather than the approach that's required, which is it fair to foist this person on the
Right,
landlord?
but you're not quarrelling, or are you quarrelling with his evaluation of the seriousness of the breach and the severity or otherwise of the tenant's, what you call tenant's misconduct in the litigation? Because if you're not quarrelling with his assessment of those, then we needn't go through all this.
Well, so what he says about them is that they were wrong
Yes,
and unsatisfactory.
yes.
Now, what is wrong and unsatisfactory is a very, very big subset. And in my submission, it would be wrong to lie. So something that is dishonest could be wrong. I'm not suggesting it is dishonest because we've been there and we've tried on that. But what I want this court to appreciate is what that conduct was that was in front of the judge that he found was wrong and unsatisfactory.
Right.
So that's where I'm going, my lord.
Well, I don't think we want to get into a whole detailed re-examination of all of the material.
No, I appreciate that, and I'm not giving you a re-examination of the whole of the material, but it is important. So,
All right, well, let's get on and you make your point.
thank you very much.
Right, so we've got his witness statement, page 76.
Yeah, and at paragraph 2.
Yeah.
I am satisfied with the works that have been carried out, which I do not consider were substantial, and mostly remedial works relating to general wear and tear and dilapidations. All buildings, works, of the property have been carried out in a perfectly adequate manner, which has been inspected by the defendant's expert witness, who visited on the 2nd of July 2021. So no reference there to the extent of the works which he was doing. Now, I need to find, sorry, I apologise, the schedule that he produced originally.
So by July 21, the landlord knows that work's been carried out.
Yeah, but not the extent of them.
Yes.
So if you turn back to page B49, this is the expert report. That the tenants wanted to rely on. It starts at page B48.
Yes.
So this application on the 6th of July was to produce this expert evidence. If you turn the bundle round so that it's in landscape, not in portrait. On page B49, and if we deal with the roof again as the paradigm example,
So it's my fault. What's the date of this document?
15th of January.
Thank you.
So if you look, there's across the top, you'll see there are a number of, the columns are noted, and surveyor's comments are Mr. Hirrell's comments, and customer comments action are the tenant's comments.
Yes.
So on the surveyor comments, it says, works to this area already completed to a good standard. Clearly no need to carry out these works.
Yeah.
And then the tenant's comment is, please find attached a copy of the work carried out by Mac Builders. So, my lord, the position is that even though they had entered into a contract on the 2nd of October to do all of the works in the schedule of dilapidations, which included those works to the roof, you'll recall, and those weren't subsequently attached, and those were the works that cost £9,400. The expert evidence that they're seeking to adduce of Mr. Hirrell, the principal of Let's Construction, is that no works are required to the roof.
Yeah. So
Well,
you may have been right. We'll do the work. We don't think it's necessary, but we'll do it anyway.
right. The surveyor, or both surveyors now, Mr. Daniels, Mr. Dickens and Mr. Colborne, have both said this is disrepair.
It doesn't necessarily follow they're right.
It doesn't follow that they're not. No, I agree, but there's no expert evidence. What the tenant is seeking to adduce as expert evidence is this evidence of the builder who's agreed to carry out the works to say nothing's needed.
Yes.
But there was no expert evidence at trial on either side.
The expert report of Mr. Colborne was adduced, but not all.
No oral
no
evidence
oral
and no
evidence.
testing of it, and
No.
no exploration of it.
No. So, my lord, the point I wish to make is this: really, if this might be inadvertently not telling the court about a contract that we've entered into to do the works that you expected us to do in your schedule of dilapidations. It's repeated inadvertence. And it's the proper approach would have been to say we have in October 2020 we have entered into a contract to carry out the works in your schedule of dilapidations.
Yeah.
It doesn't just go to the tenants saying we don't think this amounts to disrepair. We don't think this amounts to substantial disrepair. It goes to the builder they have engaged, being asked to be their expert, to say that no further works are required in circumstances in which he is carrying out the works in the schedule of dilapidations and which in due course the judge found did amount to substantial disrepair. So, my lord, if the position is, well, it's arguable that they're right, well, it isn't really, because the judge found that it was substantial disrepair. Now, they could have taken the line that they don't actually need to do any works because it isn't substantial disrepair. And we could have got to trial and the judge would have found it was substantial disrepair and it hadn't been remedied. And therefore, they weren't entitled to the new lease. In fact, they argued, we'll go to the skeleton argument produced on their behalf, that there wasn't any substantial disrepair. So they maintained the position that this didn't amount to substantial disrepair. So that was in dispute.
Yeah.
at trial.
Well, I think you need to get on to show us where the judge went wrong.
My lord, yes. On the 12th of July, having heard the application, His Honour Judge Monty gave the tenants permission to rely upon their own witness statements, but not rely upon the expert evidence. He made that conditional upon the further disclosure. And then on the 19th of July, the further disclosure was provided. And if you turn to page B269, my lord.
Yes.
I apologise, sorry, I also, if you go to page B225.
225.
B225, yeah. I'm just putting it,
Tab D. Yes.
that's the letter from those instructing my learned friend saying, here's our disclosure following the order of His Honour Judge Monty. At page B227, there's the list.
Yeah.
If we just look at that letter, my lord, on the 19th of July from those instructing my learned friends, you'll see that it says that Jason Hirrell was contacted in August. He was not able to start until October 2020. By October 2020, he was still unable to start the works because he was short of builders due to COVID. Between March and April, the road where the shop is was cordoned off for a few weeks. Eventually, Jason did manage to start works at the end of March, beginning of April. And the works were taking longer than had been expected. The judge found that that letter didn't actually sit very well with the contract, because the contract expressly said that the works don't start until April and May. So we have another, another inadvertent misleading of the court, which was again obvious. You might ask, why is it being done? Because they provided the contract. If you turn to the new B271, the A3 version, you'll see that that's the expert report of Mr.
This is the document you handed up this morning. Yeah. This is a Scott schedule attached to what?
That was what was now provided on disclosure, and it's the Scott schedule from Mr. Hirrell's report,
Oh, I
Mr.
see.
Hirrell's expert report.
So we've now got this will be revived and brought up to standard by Let's Construction. Limited.
Yeah.
Reviewed, rather, yes. Right.
Then on the 29th of, so that's provided on the 19th of July. On the 29th of November, we have the last inspection by Mr. Colborne, which gave rise to his expert report. At page, which starts at page B120 but contains his other reports. At pages B207 to 2114, it has his schedule of outstanding works.
Yeah.
So in November, it says what he regarded as outstanding.
Sorry, outstanding work. So which page? B?
B207.
207.
So Appendix J, Defendant Expert Review, comments on claimant's response to scheduled dilapidations, November 2021. So arising out of his inspection in November 2021.
But I can't read what's in the final column on the B208, what did you say about the roof then?
Action taken, roof covering in progress at time of visit, including compliant insulation.
Yeah.
And then on the 17th of December 2021, at page B218, I think. That's an email from Mr. Eads Levy, who was a...
I'm sorry, I missed the page. 218.
218, yeah. Building controller visited the site yesterday to inspect the completed roofing work. The gentleman who inspected has confirmed that building regulations compliance has been achieved. This is after receiving the information requested. And effectively the building...
The gentleman who inspected, is that Mr. Colborne?
No, that's somebody from the local authority building regulation improvement.
Follow?
But then in due course, a certificate was produced, and you'll see that His Honour Judge Monty said it was produced when the trial bundle was prepared.
Yeah.
So that late. And then finally, at B302, sorry, page B284 to B. What are the pages?
Photographic schedule.
To one of the 320s is the claimant's skeleton argument for the hearing on the 1st of
Sorry,
January
give me the
2022.
page again.
Apologise, B284.
B284.
284. I'd ask you just to turn to page B302 and paragraph 46. You'll see there the court was still being invited to find that, as a whole, the breaches of covenant of repair ought not to be classified as substantial.
But that was, by that stage, just a legal issue.
That was a
because
legal issue, yeah.
It was whether £9,000 or £11,000.
Well, it was
roof repairs is substantial or not.
It wasn't just the, so there were £30,000 worth, I think, and then it was that was the amount under the invoice or under the contract for Mr. Hirrell.
Well, I think the point was, fastening on what was Mr. Colborne said at paragraph 510 of his report,
Yeah.
quoted in the skeleton, there's an argument saying each of the items individually is minor, but taken as a whole they are substantial.
Yeah, but it's the position that there was no substantial disrepair at any point was the position that the tenants maintained throughout, even though they had contracted to carry out the works under the schedule of dilapidations. That's why that's there. So there was a dispute. There had to be a dispute before His Honour Judge Monty as to whether or not the disrepair set out in the schedule of dilapidations
Was or wasn't substantial.
Was or wasn't substantial.
Yeah.
So what are the criticisms then made of, or how does His Honour Judge Monty deal with this conduct as he approaches paragraph, so that's in tab 11, starts at page A170, my lords, in the core bundle.
Yeah.
At page 8, he deals with the evidence that he has heard
Yes.
and says, I was less than happy with the claimant's approach to disclosure and the position adopted during much of the course of this litigation, which has been to deny that there was any disrepair whilst at the same time engaging in to carry out works. I accept, of course, that that's a general summary in his introduction to his judgment. If you turn over the page, my lords, to page 173 and paragraph 17. The tenant denied this, so this is dealing with the correspondence and the pleaded positions. The tenant denied that there was substantial breach of covenant, except that there may be some minor breaches of the repairing covenant, but nothing substantial. The tenant also noted that the post office intended to carry out refurbishment works at the premises as part of its transformation project, and that would supersede, any works that the tenant might now carry out. However, the tenant said it intended to carry out such repairs as required to comply with the lease well before the matter went to trial. Insofar as that's a summary of the letter from Clark Wilmot dated the 18th of November 2018, or 19th of November, in my submission it's a very generous gloss on that, because the maintained position was that there was no disrepair, and that is how the position evolved. So notwithstanding that that's what was said in November 2018.
I thought Clark Wilmot did accept there were some items of disrepair, but they weren't very significant.
Yes.
So that's not a bad gloss, is it?
Well, in my submission, their principal point was that there was no disrepair. Any disrepair that there was minor, and in any event, it would be repaired before it got to trial.
Well, that's what the paragraph says anyway.
Yeah.
Right, let's move on.
But that isn't how it was pursued, you'll recall, in the evidence
No? All right.
of Mr. Nathan. He didn't say, I accept that there is some disrepair, but it's minor.
Mm-hmm.
He said, there is no disrepair and the repairing obligations of the landlords in any event.
Yes.
So, so be it. Other substantial breaches, I don't need to read that because that evolved during the course of the position in relation to other substantial breaches evolved during the trial. Could I ask you, my lords, to read from paragraphs 21 to 29 of...
We have read this. I should have mentioned that at the beginning. We've read the trial judge's judgment and Mr. Justice Richard's judgment.
Yes.
So just highlight the points you want to make.
Right. So the way in which the judge approached this, as indeed we have on this appeal, is by reference to the roof repairs. Mm-hmm. The judge refers at paragraph 25 to saying, in his statement in these proceedings, Mr. Nathan said that he had repaired the roof and relied on the MAC roofing invoice. So the point that I've made.
Yeah. Then he talks about Mr. Hirrell, that there's no mention of Mr. Hirrell, wasn't disclosed. Paragraph 31 wasn't disclosed.
No.
Then he looks at the contract.
That's right. Paragraph 35. The narrative in that letter, which you've been to, does not sit well with the terms of the
That
contract.
you've just shown us.
Paragraph 36, Mr. Nathan says nothing about the works that they contracted to do. Mr. Nathan appeared to accept Mr. Lane's suggestion that the claimant had engaged in a race to get the works done before the trial. 37, Miss Nathan's witness statement was in a form.
Yeah.
Yeah.
And then paragraph 38, the judge says it's unsatisfactory. The stated position was nothing, no major work required. Yeah.
Yes, absolutely.
40 says there's a genuine attempt to carry out the works in the schedule.
And then he accepts that the works were funded personally by Mr. and Mrs. Nathan.
Yeah.
He then turns to the law. What's set out in paragraphs 41, 40 to 44, I apologise, is largely taken from the extract from Woodfall, so that appears in your bundle
Yep.
of authorities at paragraph 19, and it's pretty much a verbatim
Yes.
repeat of the Woodfall position. Paragraph 47, that's also effectively taken pretty directly from Woodfall. So we then come on to how he deals with each of the breaches.
Yeah.
So, at paragraph 58, he says, I am satisfied that the breaches identified by Mr. Colborne, which relate directly to the repairing obligation, meant that the landlord has established that the tenant was in breach of covenant at the date of the notice, in that there was a substantial neglect on the part of the tenant to comply with the repairing obligations. Now, presumably, that also meant that there was a substantial breach right up to at least July 2021. Because in his inspection in July 2021, Mr. Colborne found that the level of disrepair was pretty much the same as it had been in February 2021 when he first inspected. And
We've been concentrating on the roof alone. Is that true of everything?
but it's certainly,
There's a lot else in the schedule apart from the roof.
there is a lot else in the schedule, but the judge used the roof as the paradigm example, and in relation to the roof, there hadn't been any works done. So in my submission, we can find that on the basis of his finding, that it was substantial disrepair in July 2021. To recall at the beginning of his judgment, well, you may not, but Mr. Gill doesn't just own this property, but he owns other properties in the same terrace. So he has an interest really in the maintenance of the appearance and condition of the properties throughout the term, not just when it comes to a renewal of the lease. And the repairing obligation is one to maintain in repair. It's not one to bring into repair at the end of your lease, or to bring into repair so in order to get your new lease under the Act. He then goes on to paragraph 59, my lords. In my judgment, the evidence from Mr. and Mrs. Nathan that the business they operate from the premises is their livelihood and so serves the local community is to be accepted as genuine. In my submission, that is an irrelevant consideration.
Why?
Because, presumably, that has no relevance to their performance of their repairing obligation.
No, surely, if it's their livelihood and if they regard it as important, that
Well,
it's there for the benefit of the local community, that would tend to suggest.
why does the benefit of the local? I mean, a business is a business, isn't it? Well, if I run a business, I want to make money from running my business. I don't want to run it as a loss.
What the
Well,
judge
it's
is
a
saying.
post office as well as just a business.
Well, it wasn't by now. It wasn't a post office because the post office had been removed.
No, but it also serves the local community. But the point the judge is making is that they genuinely thought that they needed it for their livelihood, and they genuinely thought there was a benefit to the local community.
So,
And the inference from that is that would make it more likely that they would want to comply with the terms of a new lease, isn't it? Isn't it relevant to that question? I don't suggest for a moment it establishes it, but it's relevant to that, isn't it?
well, with respect, I don't think the fact that it serves the local community is relevant to that.
The fact that they believe it serves the local community, that's what he's talking about. Their evidence is genuine.
Well, no,
The fact that they believe that.
he doesn't say that they believe it. He says it does serve the local.
Mr. Grundy, this is really splitting hairs.
I agree.
Do you accept the point my lord is putting to you, that whether this is their livelihood and of importance to them is relevant to the question whether Mr. and Mrs. Nathan are willing to risk the loss of a lease in the future by failing to perform their
accept that.
obligations? You accept that.
He then goes on, it strikes me that Mr. and Mrs. Nathan have had a rather rude awakening over the need to comply with the terms of their lease as a result of these proceedings, and in particular the July 2021 hearing and the need to get works done. So when we go, one of the reasons for taking you through the chronology of the way in which Mr. and Mrs. Nathan had dealt with acted in relation to the case is that this finding really doesn't make any sense. They'd entered into the contract to do the works in October 2020. What happened at the hearing?
Which finding?
That they had a rude awakening, in particular the July 2021 hearing, of the need to get the works done. What happened at the July 2021 hearing, my lord? So at the July 2021 hearing, they were refused permission to rely on the expert evidence of Mr. Hirrell that was inadvertently misleading the court.
And criticisms were made of him, I think, at that hearing, of Mr. Hirrell.
Well,
And was that not the occasion on which Mrs. Nathan, shortly thereafter, said we must get Mr. Eads Levy on board? Isn't that what the judge is referring to as the rude awakening?
well, if that's right, that doesn't really explain, does it, my lord, why they'd entered into a contract to do all the works under the schedule of dilapidations in October 2020.
No, but what it does do, so the judge thought, is lend support to the idea that they were likely to take things more seriously in terms of compliance with the lease in the future, at least post July 2021, than they might have done in the earlier stages.
So, my lord,
That's the point the judge is making anyway, isn't it?
I don't think that can stand up to any scrutiny once one knows what the chronology is.
Well, isn't the chronology, we enter into a builder who uselessly tells us that actually you don't need to do most of this work in October 2020, and the rude awakening comes in July when the claimants, the respondent, your surveyor goes on the scene, and then they're shortly followed by a hearing.
But they've already had the experts' report dated February 2021, which sets out what the position is from Mr.
It wouldn't
Colbert.
be the first litigants that don't read experts' report carefully.
But
Or indeed, don't accept what the other side put forward as needing to be done as necessarily simply to be accepted without any critical.
so, well, the position is they have already entered into a contract to do the works that were set out in the schedule of dilapidation.
Yes, as Mr. Nathan put it, they'd been told it may not be necessary, but they thought they'd better get on with it because that's what was said needed to be done.
But that's not right, is it? Because that contract was entered into with the works to start in May and be finished by July. So what kick up the pants, if I can put it like that? Does the July 2021?
But what are you saying about the judge's finding? It's irrational?
No, what I'm saying is that if one looks at this, one has to consider this by reference to the fairness to the landlord.
But wait a minute. The judge is saying that Mr. and Mrs. Nathan have had a rude awakening over the need to comply with the terms of the lease as a result of these proceedings, and in particular
The July 2021
yes,
hearing.
right.
So what is it?
I follow you say what happened in July 21. What about the proceedings? This is being pushed all the way to a contested trial on the basis of complaints about the state of repair of the property.
Well, yes.
The Nathans have belatedly done the work, which brings them into compliance more or less with the schedule of dilapidations. The judge is finding they've had a rude awakening as a result of these proceedings is surely a finding he was entitled to make.
It is, my lord, yes.
Right, so
Absolutely.
if we
But-
remove, in particular, the July 2021 hearing, you've no quarrel with
No
his
quarrel with that at all.
Right.
But he does say in particular the July 2020. So he identifies that as a particular date or a particular event.
Mr. Grundy, you know that we don't pick apart judgments like contracts.
I do, but I do understand that. So if I take you to paragraph 88, my lord, of the judgment, page 185.
88.
88.
Yes.
taken together, the balance is, in my view, plainly in favour of the tenant. And I reject the landlord's reliance on A, B and C individually and collectively as grounds of opposition to the new leases.
Yeah.
Now, in my submission, this isn't a balancing exercise. We'll go back and look at how he dealt with the conduct that I've taken you through the document.
But wait a minute. The question that he's posed himself in paragraph 60 is whether it's fair to the landlord, having regard to the tenant's past behaviour, to compel him to re-enter into legal relations with the tenant. But that's the question he's posed himself.
Well,
and he answers it overall at 88, that the balance is in favour of the tenant.
so I apologise, my lord, but if you look, the paragraph at paragraph 60 is under the heading ground A, breach of repairing covenant.
Yes.
So when he gets to paragraph 88, he's wrapping everything together. So that's not the question that he was posing himself overall. The question he's posing himself overall is whether it's fair in all the circumstances. And in my submission, that's taking the wrong approach.
So where does he say that?
He says that in paragraph 88. So if we look at his analysis,
fair in all the circumstances, where does he say that?
he says taken together, the balance is, in my view, plainly in favour of the tenant.
And that you say is a legal misdirection.
My lord, I was going to elaborate upon it by looking at what happens in relation to ground C. So you'll recall the way in which the conduct was relied upon by Mr. Lane at first instant was that conduct came within ground C. So that conduct was other breaches of conduct. That hadn't appeared in the notice because obviously it all happened after the notice, right? So paragraph 81. So paragraph 72, my lords, he sets out, His Honour Judge Monty sets out the 8 things that were being presented to him as coming within ground C. And under number 8, it's conduct generally.
Yes.
Paragraph 18. As to 8, Mr. Lane advised me to consider the claimant's conduct during this litigation, including his attitude to repairs, disclosure, carrying out work in a race to complete the repairs, all the while denying the breaches were substantial. Mr. Lane also refers to the fact that at no stage during these proceedings, and even now, has the claimant conceded that there were substantial disrepairs. In my judgment, there are clearly criticisms to be made of the claimant's conduct, as Mr. Lane has identified, and as I was set out in the earlier part of this judgment. It seems to me that the claimant's formal stance, it wasn't just their formal stance, it was their, where was their other stance? What does that mean? The formal stance in these proceedings in relation to the repairs was unfortunate and wrong. The position in relation to disclosure was unsatisfactory. I take these matters into account. In my view, they do not outweigh other matters in relation to which I have made findings in relation to ground C above. So he deals with ground C between 72 and 82. At no point is there a countervailing proposition put to the conduct.
Well, I agree. The use of the word outweigh may not be its usual sense, but isn't what he's done is from 72 before he gets to 79, he's addressed items 1 to 7 and either decided that there were no breaches at all or that they were minor.
Yes.
And then he says what he says in 81.
Yes.
And then that leads to the conclusion in 82. I'm not satisfied that the breach is proven in respect of ground C, which we must take him to mean breaches including what we're now talking about as 8 as litigation conduct,
Yes.
are substantial. So it looks as though what he meant was, I don't consider that this, i.e. 8 litigation conduct, has any greater weight than the other matters that I've dealt with under head C. And that's why he goes on to say, not satisfied that any of the ground C matters are substantial. Is that a possible interpretation of what he's saying?
In my submission, it doesn't. In order for something to
Well, it doesn't mean outweigh in the sense that one might usually use it, because as you say, he's not comparing one set of circumstances
No.
with countervailing circumstances.
I appreciate that. So
So what,
yeah,
did,
what he's saying is that
what
they
did
do
he
not.
mean? What did he mean?
Well, it could be meaning that they do not weigh more than.
Yes.
They're not heavier than those other things, which I've dismissed.
They carry
not.
no more weight
Yeah.
than the other matters, which either weren't breaches at all or were not substantial.
Absolutely.
So he's essentially saying, I don't treat this as having a weight which would make it equivalent to a substantial breach.
Yes, that is how it could be read.
Right.
But there isn't any analysis of why that conduct makes it unfair for the landlord to be obliged to grant the Nathans a new tenancy agreement.
What was the argument as to why it was unfair to the landlord? What was Mr. Lane arguing?
Mr. Lane was arguing that given their conduct during the proceedings, he shouldn't be obliged to grant them a new tenancy agreement.
Why is that unfair? Why was he saying that's unfair?
Because they can't.
You've been trying to say that the relationship between Mr. Gill
Yeah.
and the Nathans had broken down, but there wasn't any evidence about that. You really accepted that. So
Yeah.
why was the judge being asked to say it was unfair?
So the rules require them to have behaved in a different way. The tenancy agreement, likewise, a new tenancy agreement will require them to behave in a way that complies with the tenancy agreement. The rules of court require them to behave in a way that complies with the rules of court. Their conduct singularly failed repeatedly.
So failure to comply with covenants.
I mean, it's
Plus failure to comply with rules of court. Makes it unfair to the landlord to require him to grant a new tenancy.
yes. This case, my lord, went to trial on the basis of, didn't quite get to trial, but it looked like it might get to trial. Until July, it might have got to trial on the basis that the tenants were inadvertently misleading the court and the landlord.
Yeah.
My lords, if we then turn to what the correct legal approach should be, so in your bundle there is the Rent and Mortgage Interest Restriction Act, Section 3, and the Rent Act, Section 10. They're put in there to show that a different approach,
Yes, reasonable in all the circumstances.
reasonable in all the circumstances taken. In fact, it's plain from the Landlord and Tenant Act 54 itself that the phrase "reasonable in all the circumstances" was one that Parliament was aware of when it was passing the 54 Act, because that's the one that appears in relation to the determination of the terms. So that formulation would have been available
Yes.
to the court. So if you look at the judgment of Lord Justice Ormerod in Betty's Cafe in front of the Court of Appeal, that's
Don't think Lord Justice Ormerod was in the Court of Appeal for that case. Do you mean Lyons or
I
do you mean
apologise, I mean
Burkitt?
Lyons. I'm really-
Justice Burkitt.
Thank you, my lord. I mean Lyons. Thank you very much.
Lyons.
Lyons, yeah. It's page 71 in the margination, in the right-hand side of the authorities bundle, and page 879.
71. Yes.
So there's a paragraph that starts, "The contract with Littlewoods, in my view, had no bearing on," in my view, had no bearing on the case, presumably. The question was one to be tried between the landlords and the existing tenant, and it was his breaches and his conduct which were material. It remains decided whether the case should be sent back for reconsideration by the judge or whether on the material before this court an order should be made. It is true the judge said, if this were a case of a small man who would lose his livelihood, I would have said, despite the breaches, I would grant a new lease. It may be that this is an indication that he might, if the case was sent back to him, exercise discretion in favour of the tenant, although it may very well be that in saying that, the judge was regarding himself, as he indicated earlier in his judgment, having an overall discretion similar to that given by the Rent Acts. And effectively in Lions Cafe, the Court of Appeal say, no, you don't, that's not the width of the discretion in this case. And my lord, that's something that you repeated in Horn and Meredith at tab 14. In the
I
last
don't have tabs, so what's the page?
Page 188.
Yeah.
Paragraph 27. The second part of the question has been described, as you just did, my lord, as a discretion, although I would prefer to describe it as a value judgment, the phrase you've just used, my lord. The phrase ought not does, to my mind, suggest that there would usually be some fault or culpability on the part of the tenant. The overall question under this head is whether it be fair to the landlord, having regard to the tenant's past behaviour, for him to be compelled to re-enter into legal relations with the tenant. And in my submission, that is the issue that Lord Justice Newey identified when he granted permission to appeal. Is this a general discretion, not exercisable in the round, or is it one that's considered through a particular perspective? And in my submission, it's one that's considered through a particular perspective. And the authorities that support that date from very soon after the 54 Act came into force. And my lord, come up to your decision in Horn and Meredith in 2014. So that's the first issue of law raised in the supplemental skeleton argument, is what's the correct perspective. The second issue is, do you do it by reference to matters generally, or is it by reference to the limits defined by the grounds? And in my submission, it's by reference to the limits defined by the grounds. My lords, the references to the authorities are there in the supplemental skeleton argument, so I don't propose to go through them case by case. I would propose now, for the purposes of making, not requiring my learned friend to make submissions back to me in relation to the respondent's notice, if I make submissions now in relation to the date.
Yes, by all means. So you don't want to take it, you simply rely on your supplemental skeleton, do you, for...
In relation to those in relation to those two questions, what is the focus or the perspective issue?
No, I mean, this is the Yousefi and Musselwhite point versus Kent and Guest.
Yeah, and I'm not really... well, in Kent and Guest, Mr Justice Snowden, now Lord Justice Snowden, said that he thought that, or it's arguable that Yousefi and Musselwhite was wrongly decided. And that's repeated in the passage from Hill and Redmond that I took you through. I'm not... I am not sure that Lady Justice Gloucester goes as far as saying it's a discretion to be considered in the round. She still refers to the fault ground which she was considering, ground 31.
Yes, but she says focusing only on ground of disrepair, or focusing only on delay, persistent delay in paying rent. That's the point that Lord Justice, Mr Justice Snowden thought might be wrong. for the reasons that he gave.
Yes, I mean, the point, my lord, is that the ground 31C clearly includes conduct that is wider than just breach
Yes,
of
but
covenant.
if you go to your bundle of authorities, page 159,
My lord, yes?
what she says is, under A,
Yeah.
the court, this involves the court for the purpose of this subsection focusing exclusively on the state of repair and asking itself whether looking forward to a hypothetical new term, the interest of land will be prejudiced and so forth. Then about halfway down the paragraph on the next page, discretion's not circumscribed other than by the requirement that the court has to focus on the state of repair. Similar approach applies in relation to delay in rent, focuses on the persistent delay in rent and nothing else.
No.
And then under C, it's broader. Now, are you supporting that or not?
My lord, I'm saying that 31, the last 4 lines of Lady Justice Gloucester's judgment in paragraph 29 effectively repeat what the ground says.
What do you say about what she says about grounds A and B?
My lord, in order to establish whether or not the ground is made out, in my submission, she is right that you have regard to the performance of the repairing obligations or the payment of rent. And in relation to the matters under ground 31C, you have regard to other breaches of covenant or the conduct generally in relation to the management of the holding.
So if it's only an A case, if the only complaint is disrepair, she's saying that's the only circumstance you can take into account at the ought to value judgment. Are you saying that's right?
My lord, I am saying that it is right that you can have regard to matters that relate to the payment of rent or non-payment of rent. If, for example, there was
Suppose there is a case in which there is disrepair,
my lord, yes?
but if that were the only thing, then the landlord will not have established that the tenant ought not to be granted a new tenancy. There's also been delay in payment of rent.
Yes.
But if that were the only thing, the tenant would still be granted a new tenancy. Can the judge add the two together and say, looking at these grounds together, the tenant ought not to be granted a new tenancy?
So, my lord, yes.
Or do you, right, so you don't focus exclusively, you can at some stage in the analysis
Yes.
look at the grounds cumulatively
Yes.
and say, although if that had been the only ground, I would have ordered the grant of new tenancy, in view of the fact that there are there's more than one, taken together, they point against the grant of new tenancy.
My lord, yes.
Right.
But in my submission, it's not an exercise of a general discretion like the Rent Act, where you
we've got that point. But the question is whether it's compartmentalised in the way that Yousefi suggests, or whether, as Mr. Justice Snowden suggests in Kent and Guest, it's a bit broader than that. You can look at these things cumulatively.
So, in my submission, in relation to establishing whether or not the landlord establishes whether or not there is a substantial breach of those obligations, whichever ones we're referring to, you look only at those.
Well,
and then you
ground A doesn't actually refer to substantial breaches.
No, it doesn't. But it's been interpreted as meaning substantial because of the ought not. I accept that. But when you're considering within the ought, and to a certain extent that has elided the consideration of whether or not there are breaches of the repairing covenants and the exercise of the value judgment. But if the landlord makes out more than one of the grounds, the court is entitled to look at them cumulatively to decide whether or not the landlord ought to be obliged to grant the tenant a new tenancy. And in my submission, what the court is interested in is the continued performance of the tenant's obligations.
Yeah.
And if the tenant has fallen down in relation to a number of different obligations, that will inform the court as to the extent to which they can reliably be expected to perform the obligations in future.
Yeah.
So, insofar as it's establishing, it is difficult to understand what Lady Justice Gloucester is saying about, because in this case there were different grounds of opposition to the grant of a new tenancy, and in the event she found that there should be no grant of the new tenancy under 31C, and dismissed to a certain extent the findings. So it's obiter. It's also difficult to see whether what she's referring to is, do you establish the factual nexus that is necessary to give rise to the value judgment, or is she talking about both of them rolled together?
Well, obviously you can't find there's persistent delay in payment of rent by reference to the state of repair of the property.
No, absolutely not. Sorry, I don't mean by rolling the different grounds together. What I mean is by establishing the factual basis for the value judgment in the first place. So if there's no repair, you don't even get to the ought not to.
If I may say so, it's a slightly odd position for the landlord to be arguing, narrowing the ought not question, but there we are.
In this case, what we say is that the conduct which that the tenant engaged in during the litigation was about the performance of the repairing obligations, and it was other conduct.
Yes.
So it comes both within 31A and 31C. I accept that the way in which it was presented by Mr. Lane was that it came within 31C, and the judge dealt with it under 31C, and he said that those matters don't outweigh.
Yeah.
We found the other things he found in relation to the other conduct, the 31C ground. And what we say is that he in order to have made that finding, he wasn't approaching this from the position of the landlord.
Well, I understood that point. Yeah.
I'm not sure that Lady Justice Gloucester's decision in Yousefia and Musselwhite should be criticised, or is subject to the criticism which is made, because I'm not sure she's necessarily finding that the discretion is limited. What it seems to me talking about is the establishing the nexus of the ground.
Yeah. Right.
And in my submission, what the circumstances in which it is limited, the circumstances in which the value judgment is limited, really relate to an assessment of the matters which will be relevant to the relationship of landlord and tenant once the substantial disrepair is established, or once the persistent non-payment of rent is established, or once the breaches of other covenants are established. Because this is a contractual relationship of landlord and tenant, and what the landlord wants is his property back, and not to have the tenant foist on him for another term. So in effect, what the Act does is it wholly limits the landlord's ability to rely on the contractual terms, but doesn't inhibit in any way the tenant's rights to rely on the contractual terms. And so, in my submission, the perspective should be, why should the landlord have this person for another term?
Yeah. Right.
In relation to the date of, so the issue raised by the respondent's notice, really, it would be absurd if the only thing that the court can have regard to is the date of the repair at the date of the hearing. Whatever steps the landlord has had to take in order to establish that, or in order to require the tenant to repair the building. So in a case like this one, where the landlord owns other property, other adjacent property, the landlord isn't just interested in the state of repair as at the date of the hearing and the grant of a new tenancy. The landlord's interested in the state of repair throughout the term. I give an example in the supplemental skeleton argument of a circumstance in which you have repeat applications for a new tenancy, where the tenant just brings the premises into a state of repair for the purposes of achieving the grant of a new tenancy. At some point, the court must be able to say, well, you're allowing this to fall into disrepair during the term and just getting it into repair each time the matter comes before the court for a hearing. And that's not an appropriate way to behave as a tenant, and the landlord shouldn't be obliged to be required to grant you a new tenancy. If it is right that you don't just look at the date of the hearing, but you look at other dates, it must be right that you're not limited to one date, so the date of the notice. And if you
Well, I mean, that doesn't matter for your case because the judge found there was substantial disrepair at the date
no,
of the
absolutely,
notice.
it doesn't matter. But in my submission, what the court is required to do is take a look over the period of the term and decide whether or not at any point during the term the tenant has been in substantial disrepair. What the point about the date of the hearing is that the fact that the tenant has put it into repair may be an indication of their position in relation to their performance of their obligations going forward. But it is no more than that. It's no more than evidence of the fact that they've put it into repair, so they might be able to be presumed to be reliable to perform the obligations going forward. What the tenant's position in this case is saying is that the court couldn't really look at anything other than as at the date of the hearing. And in my submission, if you look at the words of section 31A, it is right that the state of the premises is in the singular. So that's on page 11 of the authorities bundle. Where under the current tenancy the tenant has any obligations as respect the repair and maintenance of the holding. So those are continuing obligations. They don't just arise when you get to the date of the hearing. The tenant ought not to be granted new tenancy in view of the state of repair of the holding, being a state resulting from the tenant's failure to comply with the said obligations. Well, the said obligations are continuing obligations, so the state must be a continuing state.
Well, you've got to have bad repair before you can serve the notice. And inevitably the judge is going to be interested, as they point out, at the time of the trial. So it's got to be more than at least one date.
And once it's more than one date, why are you limited to two? I mean, that just makes no construction or interpretation sense at all. Those are my submissions.
Thank you very much. Yes, Mr. Wicks.
My lords, if I could start with a summary of our position on the various issues that have been raised. We accept that the overall test to be applied to the value judgment under grounds A, B or C is the one that's been identified, whether it is fair to the landlord to compel him to re-enter into legal relations with the tenant. And the authorities have various ways in which that test is put. One can also refer to prejudicing the legitimate interests of the landlord. But those differences are only a matter of semantics. And that is the test which His Honour Judge Monty explicitly applied, and he was right to do so. He asked himself the right question. So.
I think Mr. Grundy would say, well, he might have asked himself the right question in paragraph 60, but then he slid off it.
Well, my lord, I hope to demonstrate to your lordship that that's not right. And I'll just make one point to be clear about. In a number of points in his submissions, Mr. Grundy has referred to ground C, but permission to appeal has not been granted for this court to look at the exercise of discretion, the exercise of the value judgment by His Honour Judge Monty under ground C.
Oh, is that right?
See, His Honour Judge Monty, as you've seen from his judgment, found that the factual precondition of ground C was not established because
We found no substantial breaches,
no substantial
and then he went on to consider other conduct.
Yes.
So he was looking at the other conduct limb of ground C.
In our submission, what he does, if we look at page 184 in the core bundle, paragraphs 80 to 82, as my Lord Justice Popplewell observed, he reaches his final conclusion in relation to ground C at paragraph 82.
Yeah.
He refers to breaches proven, but clearly in the context where he's been asked in paragraph 72 to look at a number of different issues which come under ground C, that must also be his conclusion in relation to other conduct which might not be a breach of covenant. Everything that comes under ground C. So he concludes that the factual precondition under ground C has not been satisfied, and therefore he doesn't need to get to the question of the value judgment to be exercised under ground C alone when looked at on its own in a compartmentalised way. And permission to appeal was sought.
I'm not sure that I can entirely understand how you can divide these grounds into preconditions and ought not, particularly ground C. I understand you can divide that into substantial breaches and ought not, but how can you possibly divide other conduct and ought not? I mean, if it is other conduct, he's found other conduct. He's found other conduct, namely the way the tenant conducted litigation. That's conduct, that's relevant, potentially relevant conduct. So when he says it doesn't outweigh, he must be exercising the ought not part of the ground, the value judgment, mustn't he?
Yes, my lord, I take your lordship's point that particularly in the second part, the second limb of ground C, what one has to do is find what conduct there has been,
Yes.
as a matter of fact.
Yes.
And
Well,
then
he's found that.
he has found that. He's made the relevant factual finding. And his ultimate conclusion is that there is nothing sufficiently substantial.
No, I understand
To
that,
engage
but
grounds.
conduct doesn't have to be substantial. Doesn't say so. It's a question of whether it ought not.
I see your lordship's point. I do see your lordship's point. What I just want to bring out is a ground for permission to appeal that was not successful.
Yeah.
Because that shapes this appeal, as it were, to a certain extent. So if we have a look at the grounds of appeal which are in the core bundle, behind tab 2 at page 16.
Yeah.
And at page A19, ground 8 is set out. Ground 8 is not one of the grounds on which permission to appeal was granted. So that ground is that there was an error in law in finding that the conduct of the tenant, including but not limited to that set out in grounds 2 to 5 above, and that obviously includes the litigation conduct.
But doesn't it come in under ground 5?
The litigation,
Conduct prior and during the litigation.
it undoubtedly is the case that litigation conduct is said to be relevant to the exercise of the discretion or the value judgment under grounds A and B.
Right.
And that's apparent from ground 3, 4 and 5 for which permission to appeal was granted. But in relation to ground C, ground 8 sought to challenge His Honour Judge Monty's conclusion that the litigation conduct was not conduct that amounts to another reason connected with the tenant's use or management of the premises. And the way it's put in this ground is such that the landlord established the factual stage of the other breaches and or reasons ground of opposition and or failed properly to give sufficient weight to the same. And as I said, Lord Justice Newey hasn't granted permission for ground 8.
Do you say that litigation conduct falls to be considered under A and not C?
My Lord, what I would accept is that there are some circumstances in which the way a tenant behaves during litigation has the potential to be relevant to the exercise of the value judgment under disrepair, under ground A. But it's going to be a relatively limited set of circumstances. So it's not an absolute position that I take that the court can never consider litigation conduct, but it is possible that the way in which somebody has behaved during litigation may cast some light on, for example, their attitudes to compliance in the future with their repairing obligations, which would be relevant.
I have to say, and I've come to this without a lot of baggage, if I can put it kindly.
It's probably the best way, my Lord.
But A requires the ought not, as an ought not to be granted in view of the state of repair, whereas under the second half of C, you get any other reason connecting with the tenant's use or management of the holding.
So that's why this links in to the question of how broad the factors are which may be taken into account in the value judgment is under ground A or ground B in particular. So the question which your Lordship is grappling with is the one which is revealed by the tension between the Yousefi, the passage of Lady Justice Gloucester in Yousefi, and the analysis in Kent and Guest.
Well,
No, I'm not sure it is.
sorry. Take the example I put to Mr. Grundy. You got disrepair, but on its own it wouldn't be serious enough to
Yes.
deny the tenant's new tenancy. You've got some delay in paying rent, but on its own it wouldn't be enough. Can you add them together?
My Lord, my submission is that on the grounds of the authorities, yes. We would accept that that is not an obvious reading of the language of the statute. So that after the 54 Act was passed, the courts did had a choice of whether to say this is very narrow, and when it comes to the value judgment under ground A, I am only permitted to look at what ground A says, the state of repair. And that's, I must decide on the basis of, in view of the state of repair, ought this tenant to have a new tenancy? But the cases since, particularly Lyons, Eichner, and Hutchinson and Lambert, have suggested that it's a much more wide-ranging inquiry. And in light of those authorities, we say that the analysis of Mr. Justice Snowden, as he then was, in Kent and Guest is right, and that the passage from Lady Justice Gloucester's judgment is not in keeping with earlier authority. It is, however, not part of the ratio of her decision, of the Court of Appeal's decision in that case.
Yeah.
And so your lordships don't have to grapple with a per incuriam question, but it is the case that one of the authorities, Hutchinson Lambert, wasn't cited to the Court of Appeal, or doesn't appear to have been cited to the Court of Appeal, and
Well,
certainly
I mean, if there is a conflict, we are free to choose between them.
Yes. On this particular point.
But I was on a slightly different point.
Yes, I'm sorry, my lord.
I understand what you say about that.
Yeah.
A, B and the first half of C involve breach of obligations in the lease. Repair, rent, breach of other obligations. That's the threshold. And then it's an ought not.
Yes.
Litigation conduct is not a breach of obligations in the lease. Nevertheless, it is, as we know from my Lord's judgment amongst others, it is within the second half of C.
Yes.
So to come back to your point, which was the point of entry to this, did the Lord Justice Newey give permission to appeal in relation to C? I don't myself see how, when he gave permission on ground 3 and ground 5, which are litigation conduct related, he was doing anything other than giving permission in relation to what I would, as an engineer, regard as coming in within the second half of C.
Then let me deal with it on that basis. I've drawn your attention to the fact that a particular issue was raised in ground 8 for which permission was not given. Inevitably, I'm going to have to deal with the law across A, B and C and the principles governing it. And put frankly, I have no fear, because in our submission, His Honour Judge Monty dealt with this exactly in the way that he ought to have done. And whichever way your lordships decide the question of the ambit of the value judgment should be decided, we say that His Honour Judge Monty got it right, because he's told your lordships, if I look at these grounds individually, these are the, in a narrow way, this is the answer I come to, the tenant should have a new tenancy. And if I step back and if I look at them collectively, the same answer is reached.
Yeah.
So quite a lot of the legal analysis is interesting, and no doubt it would be very helpful for this court to wrestle with some of these questions of conflicts between the authorities. But in our submission, it doesn't actually make a difference to the outcome of this appeal.
Can I just ask you a question on the proper approach?
Yes.
And my Lord Justice Lewison's question, if one looks at ought not and then confines it, compartmentalises it as to usapi in A, but you can't look at the persistent lateness of payment in B, and similarly in B you can't look at the repair. Do you get it in any event under 31C? Because that would be any other reason connected with the tenant's use or management of the holding, i.e. two near wins on A and B which aggregate to give you victory.
It must be the case, my lord, that that anything which is properly described as a reason connected with the tenant's use or management of the holding, or a substantial breach, if it's not caught by A or B, is capable of falling within C. The difficulty will be for a landlord whether or not the landlord has put ground C in their notice under section 25.
No, landlord will always put ground C in the notice.
Yes, I mean...
Well-advised landlord. Or
a well-advised, yes. And in most of the cases we see, certainly more recent cases, A, B and C are all put in together. So
So
that's
what about
the potential
other?
trap.
What was the word other? Any other reason? Does it not mean other than persistent delay in paying rent and other than the state of repair of the premises, or not?
Yes, yes, my lord, it does. It must do. But I'd like to elaborate some submissions on what's meant by the state of repair.
Sorry, just before you do that.
Yes.
Is that right? You've got two halves to see. The first half is other breaches. And the second half is any other reason connected with. Now, so far as other breaches are concerned, I see a lot of force in the point. If you say other than what, it's other than the breaches that have been identified in A and B, disrepair and rent. And I'm not sure it follows that the same is true in relation to any other reason.
Well, my lord, it's the use of the word other, isn't it? That also suggests a comparison with something that's gone before.
Yes. So in other words, it's really looking at something that isn't a breach. A, B, and the first half of C are breaches, and the second half of C are non-breaches.
Yes.
Is that the way to look at it?
That must be right. That's right, my lord.
And if that's right, then it follows that litigation conduct only comes in under the second half of C. It's not a breach.
If it's relied on as a freestanding reason, as it were, and not as casting light on something that would go to disrepair, for example. So I don't want to make the submission to your lordships that in absolute terms that litigation conduct can never be considered a relevant consideration under A or B. But I would accept and would certainly urge your lordships to see that the primary place for a complaint of that nature is under ground C.
I mean, take a case in which the allegation is disrepair,
Yes.
and the tenant fights it tooth and nail, loses. The judge finds that the tenant's been lying in the witness box, and the tenant says to the judge, "Oh, judge, I will comply with my obligations in the future." The judge surely will be entitled to say, "Well, in view of the way you've conducted this litigation, I just have no faith
Yes.
in what you say."
Yes. My lord, you've captured the point I'm trying to make, that there may be some circumstances in which the way a tenant has behaved casts light on something which is relevant to the exercise of the value judgment in relation to disrepair or persistent delay in rent. But if the primary ground of complaint from the landlord was, as it was, for example, in Horn and Meredith, I, the landlord, have been harassed for many years by these crazy tenants who keep suing me for absolutely nothing. If that's just as a freestanding reason, please don't put me back into a
No,
contractual
I follow that.
relationship with
understand.
these people. Then absolutely that firmly falls within ground C. My lord, does that help? I was just in the position of summarising our position. I think I have done on the main issues in the appeal, and on the respondent's notice. As your lordships know, we say the relevant date is the date of the hearing, and linked to the discussion I've just been having with your lordships, if the landlord wishes to complain about historic breaches which have been remedied of the repairing covenants, the place to do that is in ground C.
Under ground C.
Yes. Because what doesn't fall within ground A is capable of falling within ground C.
Under the second half of C, or the first half?
It would be the first half. If it was breaches of repairing covenants, then they would be other substantial breaches other than those which are captured by A.
So you look at substantial breaches at any time during the term, but you look at state of repair only at the hearing.
So yes, because ground C is designed to be different, and I'll elaborate on that in a moment, if I may. Just to focus, if I might do first of all on the words used in section 30, subsection 1, we quite accept that the court has no general discretion. We're not in the same field as the residential tenancy legislation. There is no general reasonableness requirement. Parliament has prescribed a closed list of grounds on which a new tenancy will not be granted. So the court doesn't have discretion to grant a new tenancy if any of those grounds are established, and the converse is also true. It can't refuse a new tenancy if none of the grounds are established. Certainly, A, B and the first limb of C involve both a factual precondition and then a value judgment to be found. And linguistically, the value judgment is linked to that factual precondition. So under A, the ought not question is said to be in view of the state of repair of the holding. B, the ought not question is in view of his persistent delay in paying rent. And under C, the tenant ought not to be granted new tenancy in view of other substantial breaches of his obligations. Just focusing on A, however, what A doesn't say, and this is in my submission important, is it doesn't say the tenant ought not to be granted a new tenancy in view of his breaches of his repairing obligations. What A is concerned with is the state of repair of the holding being a state resulting from the tenant's failure to comply with his obligations. So it's concerned with the physical state of the holding and not with the question, not primarily with the question, is the tenant in breach? Has the tenant ever been in breach of their repairing obligations?
Yeah.
And that's in contrast with the phrasing of C, where the ought not question is answered in view of other substantial breaches or other conduct. So under C, the focus is not necessarily on the physical state of the building, but on the question of the tenant's compliance with its obligations. And there's also a contrast with some predecessor legislation.
Well, if we're going on to predecessor legislation, Ms. Wicks, might that be a convenient moment to pause?
Yes, of course. I'm sorry, my lord, I didn't notice the time.
2 o'clock.
All rise if you're able to.